Hey, I'm Paul Rabley. I'm an estate planning attorney here in our great state of Louisiana. I got a question recently was talking to a married couple, and the wife in particular asked me a question. It went something like, Paul, my husband has a daughter. She's an adult, but we don't get along real good. My husband and I have joint bank accounts. And so if my husband dies, can his daughter mess with me regarding any of our joint bank accounts? So, great question, requires a little bit of in depth discussion. Most of the time, when I get the question about the joint bank accounts, the question usually is something like if one of us dies, will our accounts be frozen because that surviving spouse is worried he or she may have to pay funeral expenses, ongoing bills, and they don't want the account frozen. So, we always say check with your bank on that. Oftentimes, joint bank accounts among married couples aren't frozen when one of those people passes away. Now, with investment accounts, a different story, real estate, a different story. But when it comes to bank and credit union accounts, checking and savings accounts that are joint, you know, typically the surviving spouse still has access to that. Check with your bank. But this question goes a lot deeper than that. So the initial worry that she had that her accounts would be frozen wasn't a concern anymore to her because she had checked with the bank. The bank told her, yeah, if your husband dies, we're still going to give you access to the money. We're not going to freeze the account. But it goes a lot deeper than that. So I want to go through what happens when, for example, someone in that situation, like the husband dies, he's got no legal plan in place. I'll remind you at the end that with the proper estate legal plan in place, all this difficulty can be avoided. So if the husband in that circumstance where he has a wife, they have community property, and they have maybe some bank accounts, maybe joint accounts, maybe in his name only, maybe in her name only, it doesn't matter, and he has a child who's not the child of his surviving wife, here's what typically happens. Well, we have some state law that dictates what happens to his stuff because he didn't make any other plans. So we have one provision that refers to the usufruct of his surviving wife that says if the deceased spouse is survived by descendants, he had a child, the surviving spouse shall have a usufruct over the decedent's share of the community property to the extent that the decedent is not disposed of it by testament. They had some community property, he didn't leave a will or nothing, and so his wife gets a usufruct over his share of the community property. Let's look at just bank accounts for now. Forget the home, forget the property, forget the investments, just the bank accounts. And let's say, I'm going to pick a number. Let's say they had $400,000 of bank accounts and it's community property. They acquired it during the marriage. So half of it's hers and $200,000 of it is hers. And his half, his $200,000, according to our state law, she inherits this usufruct over that $200,000. And his child, his only child, is the naked owner. So let's keep going. All right. So next we have to talk about some of the security rules that a usufructuary sometimes must follow. So I've got one here that says the usufructuary, that surviving wife, and I'm having a bad hair day, shall give security that he will use the property subject to the usufruct as a prudent administrator and that he will faithfully fulfill all the obligations imposed on him by law or by the act that established the usufruct unless security is dispensed with. So what that means is there's protections in place for his daughter to require that she give security, which will protect the daughter in the event that that surviving wife goes out and, let's say, squanders the money. All right, how much is the security? Well, the security shall be in the amount of the total value of the property subject to the usufruct. So the more stuff that your spouse has usufruct of, the greater the security your spouse must give. All right, so let's go back. And now, I will say sometimes security is what's called dispensed with, where it's not necessary, but not in the case where the surviving spouse, this naked owner, is not a child of the usufructuary when he died without a will. In that case, that security is not dispensed with. So here's the deal. He died. He had an adult child. He had no legal plan in place. They had $400,000 of joint bank accounts. The accounts aren't frozen. Sometimes they are, but in this case they weren't. Bank's going to give her access to all of it, but that's not the end of it. Now they've got to go through a court proceeding called a succession or probate together. They'll each have lawyer or lawyers to represent them. They're probably not going to get along because the daughter wants to protect her future inheritance. She doesn't really get the $200,000 or get the assets until that surviving wife either dies or remarries. And so they have to go through that court proceeding together, represented by lawyers. All of the assets that the couple had have to be disclosed as part of that, court proceeding. The daughter of the deceased husband can and will force her surviving, stepmother to post that security. She's going to have to go to some type of insurance agency or insurance company that is in the business of selling what's called usufructuary bonds. And she'll have to pay what she considers a lot of money, and she'll have to pay money likely every year to maintain that bond for the rest of her lifetime in order to protect her stepdaughter's inheritance. So at that point, we usually hear some kind of comment like, my husband would be rolling over in his grave if he knew what his daughter was doing to me. Or maybe we'll hear something like, I hope she's happy because I'm never going to talk to her again the way she's treating me now. Or maybe we'll hear a statement, something like, if my stepdaughter's going to be like that and make me post a bond, just give her the damn money. So all of those things are unfortunate. All of them can be cleared up by putting the right type of legal plan in place. Make sure your spouse is protected. Make sure your children are protected. Make sure all these government intrusions, all the lawyer difficulties, all of the animosity, all kept to a minimum or at best completely avoided by putting things in place. You've worked so hard to earn it. Now it's time to take a little bit of effort to protect it. So I hope this helps. If you like the video, you want to kind of be aware of more, make sure you just subscribe to my YouTube channel at Rabelais Estate Planning. Perhaps like the video, give it the thumbs up. And then if you have something maybe valuable that others can benefit from, feel free to post it in the comments below. I'm Paul Rabelais. Now go out and have a great day. Take care.